Hello, everyone, and welcome to Uncivil Law. I hope you're having a great day today, as always. I hope you're staying safe. Hope you're social distancing, all that good stuff. Hope you're well. Hope everyone in your family's well. Excuse me. That's a great way to start the stream with a sneeze. Fantastic. And we are here today with our continuing coverage of the Vic Mignogna case. Today, we are going to be doing the appeal brief of Rial and Toye. Yesterday we did Funimation's reply brief, or their appellee brief, not their reply brief. Those are technically different things. So, the appellee brief. And today we're doing Rial and Toye. So yesterday we concluded that Funimation, at least, looks like they're off the hook. We projected, or at least I projected, an 85% chance for Funimation to win because the arguments that they have, it seems like they are pretty well insulated. But of course, what applies to one does not necessarily apply to the others. So today we're going to be doing Rial and Toye's appeal brief. Now, I have been informed by other people that there's an issue as to word count as to this. I'm not going to go through the rules and figure out whether or not they are or not an exceeding of the word count. If they are, then they'll be forced to file a complying brief, which I assume will be substantially similar to this. It'll just be reduced down. So they'll take out 10 or 20% of the fluff and be able to say essentially the same thing. So are they over the word count? Maybe. Do I think it really matters that much? Not really. If they're over the word count, the appeal brief they'll make them file a different appeal brief. So whatever, it's fine. So we're going to go through this, and it is 98 pages long. Obviously, we're not going to read the whole thing. We're going to skip around. We're going to do what we did yesterday, and we're going to try to analyze the arguments and see how it goes and just see what we think. How are Rial and Toye looking in terms of theirs? So we get a whole bunch of index of authority, list of appendices, statement of the case. Okay. This appeal arises out of a textbook slap case filed by Vic Mignogna against Rial and Toye for comments they allegedly made about him on the internet. Okay. Mignogna is a public figure whose underlying lawsuit was an all-out assault on Rial and Toye, designed to silence their right to speak publicly on a matter of concern. I wouldn't quite put it that boldly, but, again, they're writing from their point of view, so that language makes sense. Mignogna filed underlying lawsuit against Rial and Toye as well as Marchi and Funimation. Marchi. He then filed a First Amendment petition. Mignogna alleges four causes of action: defamation, tortious interference, and conspiracy. Yes. After agreeing to extend the deadline to file so the parties could conduct discovery, Rial and Toye filed a motion to dismiss pursuant to the anti-slap. The parties then signed a Rule 11 agreement that extended Mignogna's deadline to file a response to August the 30th. Despite the extension, Mignogna not only missed his deadline, but also submitted a filing that had blank spaces, missing citations, and attached fraudulent affidavits purportedly sucked by Chuck Huber, Christopher Slosich, and Mignogna. Again, fraudulent is an interesting word to characterize it. I don't think it was fraudulent, but again, they're writing from their point of view. It was mistaken. It was, I wouldn't say illegal. I'd say it's not legal, because illegal implies criminal. Not legal means non-conforming to law, right? So it was not legal. But fraudulent, I don't know. It was sloppy, let's say that. Regarding the affidavits attached to the untimely response, recognizing that they were defective, they withdrew them from consideration. Great. This is significant because the February the 20th opening brief relies heavily on factual allegations arriving out of the withdrawal affidavits, particularly statements that are both objectionable and not part of the appellate record. Fair enough, if you can't really rely on stuff that's not part of the record, so you can't refer to things that aren't there. So they're arguing that the brief is defective because it's arguing on things that don't exist. Right? That's one of the penalties you get when those things get, stricken. It's like all those incorporations that you did by reference. Well, you can't incorporate something that doesn't exist, right? After withdrawing the affidavits, Mignogna filed a second amended petition 3 days before the hearing with brand new arguments and evidence seeking to circumvent the statute and the Rule 11 briefing deadline. Rial and Toye properly objected and moved to exclude the Second Amendment petition because it included new arguments and inadmissible evidence that Mignogna was using to oppose the anti-SLAPP. The trial court correctly concluded the untimely Second Amendment petition and evidence, acknowledging surprise and prejudice. Which, like, all else being equal, in the absence of any rule to the contrary, like, again, just sort of like without consideration of any particular rule that applies, right? Just sort of in the naked, objective sense of justice, is it really fair to spring on your opponent 3 days before a hearing a completely new, because essentially was a completely new petition with all this new stuff? Because they went from like 15 pages to like a couple hundred pages, right? Is that really fair to their side? I mean, I don't know if the rules necessarily allow for it or not, because I'm not that deeply sunk into Texas procedure. But on some sort of fundamental fairness level, it doesn't seem particularly fair. You're going to have a hearing on this, and 3 days before the hearing, you're going to dump this huge stuff on the other side. And they're going to say, well, that's not fair. Well, absent of a rule that would tell us what the situation should be, because the rule will tell us whether it's fair, but absent, the rule, absent sort of like the metaphysical, is it fair? Not really fair to surprise your opponent, with just dumping all the stuff. They have no time to prep, no time to argue. I mean, it's just not fundamentally fair. So I don't know if the rules allow for it or not, but I can't really fault them. You slap this huge thing 3 days before this critical hearing, and they don't have time to prep for that. That's insane, So it's, was Beard trying to get away with something that he thought he could get away with? Maybe, but the other side screaming it's not fair. Well, it's kind of not fair. To all the Vic supporters out there, I just like imagine the other way around. And maybe it was the other way around at some point. Maybe it was the other way around, and maybe you guys did object. It's like, what's good for one is good for the other. How happy would you be if 3 days before a critical hearing for Vic, the other side like dumped a whole bunch of stuff on him? And maybe you're saying, well, that did happen, and it was unfair then. Well, it's like, well, if it's unfair for us, it's unfair for them, right? So like, they can't surprise us, we can't surprise them. We don't do trial by ambush in the United States anymore. This is not really a thing. Everyone has to come and make their case in advance so everyone knows what's going on. We don't really do the trial by ambush thing. We haven't done the trial by ambush thing in, a couple decades. So, it doesn't seem fair on its face. So unless the rule explicitly allows for it, and I'd say it's not fair. So unless there was a rule that told me as a judge I have to allow this on a basis of fundamental fairness, I'd say, no, you can't do this. I'd say you can't do this. It's not fundamentally fair. It's not just like you added one thing. It's not just like you added a small thing. It's not like it's not that big a deal. It's a big deal. It was a lot of stuff. So it was unfair. So you come to me as Judge Blackleaf, and in the absence of any rule that tells me what to do, you say this is unfair. I'm like, you're right. Strike it down. And in the absence of any rule, judges get quite a lot of latitude for trial management. They get quite a lot of latitude in terms of like when things have to be there and when they don't have to be there. So in the absence of a rule that tells us otherwise, the judge gets wide latitude in terms of like when things have to be presented, when they don't. They can impose on you. As long as they like trying to, they get lots of latitude. So, you do this to me, and I'm like, that's not fair. Screw you, So unless there's a rule that says it's okay, it's hard to fault them for excluding it if that's what happened, right? The trial court dismissed all the claims against the defendant. As directed by the order, the appellees have to pay some money, blah, blah, blah. They aired some notice. They affirm dismissal, blah, blah, blah. They want oral argument. Fine. Issues presented. We'll just skip that. Statement of facts. Mignogna is a 56-year-old voice and screen actor with 350 acting credits to his name, and in his words, has amassed a pretty significant fan base. So basically a party admission. So you're looking to whether or not he's a public figure. Look to what Mignogna says. If Mignogna effectively says, I'm a public figure, you're there. Yeah. He also claims to derive a sizable income from appearance fees and signing autographs, taking photos of fans, and appearing on guest panels. Yeah. His most prominent role developed from 2004 to 2018 when Mignogna alleges he was a voice actor in at least 10 films or anime shows produced by Funimation. I don't know that you necessarily need to say alleges here. It's just like overly cautious because like no one disputes it, right? I mean, he was like that's not really an element, but it's probably just like out of habit by the attorney just to write alleges. Fine. I guess it's one of those things like you don't really want to admit it as true, even though from your point of view you want it to be true. So it's just a weird thing, but okay. Mignogna, the Funimation cast Mignogna as the voice for Broly in this movie. It earned some money. In addition to being a prominent voice actor in a widely successful anime movie and featured guests at anime and other conventions, Mignogna also acts in front of the camera with on-screen credits. He also has written, directed, and starred in a web series based on Star Trek. In fact, Mignogna is so popular, his verified Twitter account has over 113,000 followers. I don't know. Is that significant? I don't know. And since 2008, he has a dedicated fan club called the Rizumbull Rangers, a reference to one of his most favorite characters. I I don't know how significant the fan club is, or the Twitter is. Like, is 113,000 followers a lot? I don't know. Is him having a fan club significant? Probably not. But, when we looked at Funimation's argument, Funimation said, he goes to 35 to 40 conventions and has been doing this for a couple decades. I'm like, public figure, check. Check. If you're going to conventions essentially every other week, a little bit more frequently than that if you're doing 35 to 40 a year, right? There's only 52 weeks in a year. So if you're going to a convention more than every other week and appearing in public in panels and signing autographs, are you a public figure? Yeah, kind of, sort of. That's for me. It's where I was like, okay, I'm just kind of done. He's a limited purpose public figure. I don't know at what point he crossed that threshold, but if you're going to 35 to 40 of these and you've been going there for a decade, probably a public figure at some point in that threshold, yeah. So I was pretty good with the public figure status. After years of reports and rumors about sexual harassment, accusations concerning misconduct erupted on Twitter. That Mignogna was a homophobic, rude asshole, been creepy to underage female fans for 10 years. I've been screaming about this since 2010. Sure. The Twitter user tagged Funimation in a post asking, hey, Funimation, why do you employ a known pedophile? The post also included a link to previously published allegations about Mignogna's sexual misconduct. Helena's post received 8,400 likes, 4,000 retweets, and 4,400 comments, many of which discuss specific examples of unwanted and unsolicited conduct. Importantly, Mignogna has no evidence that Rial, Toye, Mariachi, or Funimation had anything to do with this Twitter post. The one that argued the one that started it, the initial thread, which I don't think Mignogna was arguing that they had anything behind it. They didn't start the fire, they just kept it burning, was basically Mignogna's argument, as I understand it. Quoting a deposition, do you have any evidence, any proof, any indication that any of the defendants had anything to do with someone putting a tweet about you on January 16th? I do not. Again, party admission, basically, right? It's coming from him. Fine, it's a party admission. We're all happy. Helena was not the first person to... I don't know if that deposition is actually part of the record or not, but whatever. Helena, it doesn't matter if it's, well, it does matter if it's not part of the record, but like you could bring it in another way, like, because it's a party admission, right? If you got him on the stand and like ask the question. So, it's fine. Helena was not the first person to bring accusations. Rather, her tweet merely reignited pre-existing discussions. Long before Rial or Toye have alleged to tweet anything, there are published reports about Mignogna's predatory behavior. So there have been lots of allegations, which is basically saying we didn't start the fire, which I don't believe was Mignogna's argument. I don't think he was arguing that they started the fire. I think he was arguing that they promoted the fire and called conventions and got his gigs canceled. So, okay. I'm not sure that particular aspect is in dispute. Fair enough. Following the release of Dragon Ball Broly, Mignogna immediately inserted himself into the online discussion by posting online statements responding to the accusations. His first order of business was to sound the call of arms to his fans, the Whatever Rangers, by personally asking them to combat negative stories and do whatever you can to counter all the lies and negativity. Yeah. Again, if you weren't a public figure before, all this, Vic, when you tell your fans to go forth into the world and do whatever they can, you have basically made agents of all these people. So, if you weren't a public figure before, engaged in a public discussion, at this point, you've basically deputized the world to engage in a public discussion. So, if you weren't a public figure before this point, which you were, you definitely are now. So, it's fun stuff. You know, I don't know how to explain this to people, but things do have consequences in the real world. Things have consequences. So when you say, "Hey, my adoring fans, please go do whatever you can to dismantle the lies," well, you've engaged the public. You've engaged the public debate. It's like you have created it. If it didn't exist before that point, you have now created it. So that's kind of significant. I think he's a public figure, guys. Just saying, I think he's a public figure. Mignogna's self-interested apology failed to have an intended effect. In the following days, several articles appeared. Okay, so there's a whole bunch of stuff. There's a whole bunch of articles that appeared about him raising allegations, which is, if anything, would go to show mitigation, potentially. Like, whatever damage occurred didn't occur from us. We weren't responsible for the original tweet. We certainly weren't responsible for Vic going forth into the world and saying, let's have a public debate about this. We were definitely not responsible for that. And we're not responsible for the news media picking up on it and publishing a whole bunch of articles. So, it's going to show either a mitigation or lack of causation, right? It's not that we called these people and got them to do it. They were going to do it anyway. Or it didn't matter that we called them because they were already primed to do it, right? So lack of causation. It wasn't us. It was all the media. Mitigation. It was us, but it doesn't matter because all the media. Okay, so they're setting up like a mitigation, lack of causation kind of thing, it seems to me. Andrew asks, him being a public figure or not, when the defamation took place is what matters. Yes, it would. But of course, then we're dealing with what statements become defamatory at what point, right? So at this point, we're looking to Rial and Toye's participation. So we're looking to things after he became a public figure, right? So I think he was a public figure in the first instance. Because he'd been going to conventions, 35 to 40 of these, according to Funimation, for something like a decade, and signing autographs and taking photographs and like all the rest of it. So I think he was a public figure at that point. But if he wasn't, I think he was a public figure at the point where he's like going, say, go forth, fans, and go forth. So yes, the relevant question is, you look to the defamation as the public figure status as to the time. You're right. But to the extent that Rial and Toye are participating in this, if it occurred after Vic did his thing, then Rial and Toye would have we're not responsible argument because he's a public figure at that point, right? So maybe these other tweets defamed him, right? That's possible. Maybe the original tweet defamed him. Maybe he wasn't a public figure at the start. And so maybe the original tweet defamed him. But if we are not behind it, we're not responsible, right? Maybe, all these stuff that happened, he wasn't a public figure. But if we're not responsible, if we didn't participate, we're not responsible. But then he went forth into the world and did this. So anything we did after that point, he was a public figure. So you can only hold us responsible for what we did. And if we only did stuff after this point, well, okay. So yeah, yes, you have to look to when he was a public figure and when not. But if all the things that they did were after that point, then okay, whatever, right? So that's what I'm saying. What is the standard for being a public figure? Well, the exact, I'd have to paraphrase it, because I'd have to look at the exact standard in the law. But essentially, a public figure is, well, let's go with the true public figure, or the general public figure before we will be unlimited, right? So the general public figure is one who is one of particular note and particular interest to the public at large, right? So you're normally thinking about the president, notable senators, notable congressmen, arguably all senators, arguably all congressmen, notable governors, arguably all governors, um, A-list celebrities. They're people who have deliberately, consciously injected themselves into the public sphere in one way or another, right? All these people that I just mentioned have very deliberately, intentionally injected themselves into the public consciousness. They have their livelihood and profession requires on them being public and notable and out there. It's like, okay, you're a public figure because what you did, right? So limited purpose public figure is doing exactly that. It's just limited to a particular domain, right? Not all purposes, but limited domains. So like is Vic a public person for all purposes? No, probably not. Not for at least a reason. I never heard of him before this stream started or this case started. I never heard of Mignogna. I don't know anything about him. So he's not, probably not general purpose. If he was, probably I would have heard of him at some point, but no, not so much. But is he limited purpose? Has he purposefully, notedly, repeatedly inject himself into the public sphere in whatever domain we're talking about? Like, yeah, a little bit. Especially when you say, go forth, my pretties, go forth in the night and fix my reputation. That kind of did it. That's kind of like purposefully injecting yourself into the public consciousness. It's like you're purposefully putting yourself into on the public stage. Well, there you go. So you're there. Could he get a limited trademark? Possibly, to the extent that he was using it in commerce. So if he had a Vic Mignogna merch and was using his name as a trademark element, then sure, probably. I mean, again, it would go to the same kind of element, right? His name would be distinctive in the relevant domain. You can show like it's relatively distinct, so you can get the relevant trademark status. Probably. Yeah, I'd imagine, to the extent that he was trying to do so, sure. Yeah, we're back, Isaac. We are back. Beginning in 2019, with renewed allegations were swirling, Funimation lost the investigations. Part of the investigation, Denbo interviewed some people. Funimation is not the only company to take action. After doing so, Rooster Teeth terminated its relationship. Critically, not a single convention or studio came forward to say the cancellations were because of something Rial or Toye have allegedly said, which I believe is correct, but that may be correct at least in part because of the discovery freeze, and maybe in part because evidence was thrown out. But this is why I was saying before, like, you can do discovery without doing discovery, right? We just called it an investigation, not discovery. The discovery is formal process, right? Discovery is where I have formal subpoenas, formal requests, all that kind of stuff, right? But I can do discovery without doing discovery. And so how I do that is I hire a private investigator normally, and I get them to like call people and get information or like send emails or whatever. So like trying to get information in advance would have been helpful. It's not clear that that was done here. So that's a problem. Yeah, and hello Tactical. It is our chief moderator, Tactical Bra. Hello, chief moderator, Tactical Bra. Tactical Bra is correct. Yes, a mayor would be, yeah, a mayor in their own town would be a public figure. It would be limited to the town, but sure, but not for all purposes. But again, unless you're a particularly notable mayor, right? If you're the mayor of New York City or the mayor of Los Angeles or the mayor of Chicago, probably you're all-purpose public figure because you're so big. If you're the mayor of, to throw out a random one, Des Moines, Iowa, probably not. So yeah, that's exactly what we're talking about. And Railway Hacker, that anyone on the board of directors is a public figure. That case dealing with public figure status of corporations was a Michigan law case that we covered on a previous stream. I don't know if you're referring to that. There was a Michigan law decision from I believe it was the Michigan Supreme Court. And it may have been being decided by a court of appeals, but they were referring back to the previous decision in the Michigan court that held that all companies in Michigan are public figures. But that was Michigan specific. So that may not apply in other states. That case we covered was a Michigan specific decision. So all companies in Michigan are public figure. That may or may not apply outside of Michigan. This was a Michigan specific case. Yeah, so Toronto mayor that did crack would definitely qualify. Yes, is it possible to have a fan club and not be a limited purpose public figure? Yeah, I think so. Depending particularly on the size of the fan club, right? So like, yeah, if you have a fan club and there are 5 members in it, then probably not. So yeah, sure, it's possible to have a fan club and not be a limited purpose. Yeah, I think so. Rial had worked in voice acting over the last 20 years, including with Mignogna. Seeing how internet commentators were sailing Mignogna accusations of liars, Rial did her own account from a convention in 2007, which was the lamest account ever. Right? Testifying that when she and Mignogna were guests, Mignogna unexpectedly grabbed her in a bed, aggressively kissing her, pushed her on the bed, climbed on top of her, and began to aggressively kissing her. Okay. I retract what I said about 5 seconds ago, where I said it was the lamest complaint ever. I thought this was a different complaint. I apologize. I thought this was the one about eating a jelly bean or some crap like that. No, no. If the accusation was that he pushed her onto a bed, climbing on top, and began aggressively kissing you, that's a more serious accusation. Yeah, yeah, yeah. Other women came forward and described a similar experience. Records replete with evidence from countless sources describing similar experiences and knowledges of reputation. Okay, perhaps there's no clear evidence of his status as a public figure and the retaliatory nature of the lawsuit that online fans created to fund the lawsuit. Well, I don't. That may or may not be dispositive. In February 2019, Minnesota resident Nick Rikita, hi Nick, contacted Mignogna to express support for the Vic Others situation and to set up a GoFundMe, as well as bloggers, corporations, and pseudo-anonymous keyboard warriors. The war chest raised $257,000 in order to help Vic kick back. Okay, which again does tend to somewhat suggest he's a public figure. If you can raise $257,000, it's at least partially suggestive. It's not necessarily dispositive. I'm sure people have raised that kind of money without being public figures, but it's suggestive. The fund is set up for Vic's legal defense. There are many possible defendants in different jurisdictions, from boring bloggers to multi-million, billion-dollar corporations. It takes an agile and experienced team to coordinate this kind of strategy. I will refrain from overtly commenting on whether or not they indeed hired an agile and experienced legal team. Yeah. It's time to fight back. Brigades of pseudo-anonymous keyboard warriors cannot be allowed to defame and destroy decades of goodwill. Companies cannot rely on non-credible accusations and devastate a career for virtue points. Well, as to the general proposition, I agree. I'm skeptical of Me Too. I'm skeptical of virtue points. I'm skeptical of social justice warriors. So it's like, yeah. Rial, Toye, and Marchi publicly posted their comments. Vic not only had fans like Rikita attacking appellees online, he also sent his friend Chuck Huber to threaten litigation if the women did not issue retractions, stop making allegations. Specifically, after several exchanges, Huber sent Rial to say Mignogna was gearing up for legal accusation unless they kept quiet. Please don't mistake this negotiation as some weakness on their part. It's my effort to try and stop something I know will be very damaging. They have full court press prepared. It's not a minor effort. They'll be extremely thorough both in legal and social spheres. Again, one might comment on the degree to which they were extremely thorough in the legal sphere. Mignogna's entire strategy was to unleash a tort of instant abuse coupled with litigation. I don't know if that was their intent or whatever. It seemed to be a little bit behind. Go forth into the world, my pretties. That one, a little bit, yeah. These harassing and abusive tactics waged alongside the lawsuit were specifically designed to accomplish the silence intent, silence accusations, and retaliate. I like the way this is being written. It does go to show that it's more anti-slap in nature, right? It does go to show it's retaliation in nature. I like the way this is being cobbled together. These attorneys are pretty good attorneys. They're doing a pretty good job making the case that this was anti-slap and malicious. Not bad. Unable to extort silence. That's a little bit flamboyant or inflammatory, but again, it's legal. So, you write it. If you want to write that aggressively, write it that aggressively. I don't know that I'd personally write it quite that aggressively, but, okay. Mignogna filed claims against Rial and Toye, all of which arise out of direct communications that are a response to the right of free speech. Specifically, Mignogna filed suit against Rial and Toye because they communicated with Twitter followers for the collective purpose of publicly discussing sexual misconduct. Well, that's kind of true. It depends on the legitimate nature of the collective purpose. It depends on what you were saying. So, If you were getting together with other people to have legitimate discussions, that's fine. If you're getting with other people to slander and defame and libel, that's not so fine. So, depends what you were doing and why. Mignogna vaguely alleges that one or more defendants began actively defaming directly to anime conventions. Yes, that is the chief allegation, the big allegation here, right? Telling people about the investigations and him being fired. These communications are at the heart. He's retaliating for sharing their personal experience and opinions about dangerous predatory behavior, especially behavior towards underage fans. Well, I guess it goes directly to what they said and what they didn't say, right? If they were recounting their own experiences and they were doing so in a truthful way, then that's probably okay. If they were laying other people's experiences, that's a little bit more dubious because they don't know, presumably, if it's truthful or not. So it depends what they were saying and how they were saying it. And it's certainly the case that if they were just making shit up, it's not okay. So it goes to like what's going on or not. Mignogna contends that Rial and Toye's online comments cost him several convention contracts and harmed reputation. Although Mignogna never identifies his contracts or specifies how, the evidence overwhelmingly contracts this laughable proposition. Okay. That's, again, overly aggressive for my taste, but fine. As an initial matter, the negative press, I'm not sure why negative press is in capitals here, as well as several affidavits, show Mignogna had a poor reputation long before the tweets were posted online. In fact, 16 individuals submit affidavits attached to the anti-slap, showing that Mignogna already had a bad reputation and was seen as a sexual predator. Well, that's not really the operative issue. The operative issue is the degree to which the convention people were aware of those and the degree to which they relied on those as part of their decision. So the impetus for what they did and why they did it is more the issue. So did he have a reputation in the community? Potentially. But not to put too fine a point on it, but he'd been going to conventions for years and years and years and years. So whatever general reputation he had apparently was not a problem, right? Because they kept inviting him back over and over and over again. So even assuming he had a bad reputation, apparently no one cared because they kept inviting him back, right? So either he didn't have a reputation or he did and no one cared. So either way, there's something here that suggests something changed, right? Something changed, right? If it's true that he had a generally bad reputation and people knew about it and all that stuff, well, he was going to 35 to 40 conventions for years and years and years. So what changed? That's a question. What changed? If it was because of you, and and you were spreading falsehoods, then that's material. Yeah. Andrew says, Vic's comment is out of context. Analogously, it's like telling people who frequent your restaurant to talk positively because the reputation is being attacked by false views and trolls. I don't know how that analogy saves the construction, right? If you are telling people to frequent your restaurant to go forth and correct the record, you are telling them to go into the public sphere. And you are creating a public sphere assuming one didn't exist before. So if you are deliberate, because public figure status is about injecting yourself into the public. So if you as a restaurant are telling people to actively go forward and actively, to spread good things, then assuming a public sphere didn't exist before, you are creating one, right? So I don't know how the analogy helps you, because it would say the same thing flows. There were negative things that were being said by others, and now Vic wants to say positive things. He's creating a public sphere, assuming one didn't exist. The restaurant had negative things saying about. Now they're saying purposefully, go forth and say good things on our behalf as our agents. Go forth and say things. You're creating a public sphere if one didn't exist before. So I don't know how the analogy saves you. If you tell people to go forth into the world, you're creating a public space. Mignogna states falsely in his brief that before the cancellations list in his brief, Vic had never had a convention cancel his appearance. The record, however, tells a different story. In reality, Mignogna has been banned or asked not to come back to conventions several times because of misconduct, all before the tweets. Okay, that's interesting. Well, this could be a very sort of precise thing by Vic too, because look exactly what Vic is saying, right? So this goes to show, like, we got to read the statement carefully, like a lawyer. I was channeling my contract professor and trying to intone that in a particular way. Got to read the statement carefully, like a lawyer. All right. Anyways, so let's read it carefully like a lawyer. Before the cancellations listed in the brief, Vic had never had a convention cancel his appearance. The word cancel pops out at me. We're being precise. We never had him cancel an appearance, right? And then they talk about how Mignogna was banned. But to Mignogna, that may not be the same thing, right? I was banned, sure, but I never had an appearance canceled. I had all my appearances go through, and then one day they say, yeah, we don't want any appearances anymore. But they never canceled an appearance on me. They banned me. They never canceled me. Precision in wording, my friends. Precision in wording. After a brief return, was banned again after being caught in a hotel room with an underage female. Likewise, Anime Central Convention received complaints and banned him from that convention. Banned is not the same thing as canceled. Precision in wording, my friends. Precision in wording. This is how lawyers use the craft of words. We use them precisely sometimes. Following an agreed delay so the parties could conduct discovery, Rial and Toye filed their anti-SLAPP and supplemented. The parties filed a Rule 11 agreement, continuing the hearings to September 6th to give Mignogna more time to respond and set a briefing schedule. Despite receiving an extension, Mignogna filed a response late, along with a motion to leave to file an untimely response, which the court granted. I think that particular one was because he was late because of technical issues. He's like late by a half hour. So normally the court will give you that slack. Although I've seen courts burn attorneys for that. The untimely response was still rife with missing citations and other errors. More importantly, untimely response was based on sham affidavits. Again, I wouldn't necessarily describe them as sham. I'd cite them as legally incorrect or not legal, as opposed to illegal, not legal, by Mignogna, Huber, and Slasach, who were not executing the physical presence of a notary, who also happened to be the lead counsel. Yeah. To avoid the consequences involved with the notarizations, Mignogna's counsel filed a notice to withdraw the affidavits. Fair enough. Yeah, and he withdrew them. We know that. Therefore, the 13 references in Appellee's brief to statements are improper because the evidence is withdrawn and excluded. Yeah, fair enough. You can't refer to stuff that doesn't exist. That's fair enough, you can't argue with that, really. After filing his response late and withdrawing the affidavits, Mignogna shamelessly tried to circumvent the scheduling agreement, filing an untimely and improper second amended petition 3 days before the TCPA hearing, attaching inadmissible declarations, exhibits, and arguments, and asking the trial court to consider this improper pleading as evidence to the anti-SLAPP. Just on fundamental fairness alone, 3 days before the hearing sounds fundamentally unfair. So again, unless there's a rule that specifically allows for it, if you came to me as a judge, I'd be like, I don't think so. These aren't like a minor thing. It isn't like, oh, you're adding just one thing or you're adding just one declaration. There's probably a line somewhere where I'd let you get away with it. But the difference between the First Amendment and second was not exactly in that threshold to me. No. Mignogna also then filed a supplement to a second amendment, making another attempt to introduce. Appellees, together with Marchi, filed a joint response to the motion. Appellees argued the late filing and submission of evidence was prejudicial and constituted unfair surprise. It's a pretty solid argument, right? Because it's a pretty consequential thing. Yeah, I can't fault that. I can't fault the argument, again, without the rules in place to know, but in the abstract, sounds fundamentally unfair to me. The anti-SLAPP motion was heard, and then the trial court dismissed all the claims. Dismissal order states trial court did not consider the withdrawn affidavits and did not consider late filed evidence because the evidence was untimely. Fair enough. Yeah. And then also, incidentally, because I know, like, this came up where someone said, well, the judge admitted to reading it. All right. I'm going to try to say this. reading it and considering it are not the same thing, right? To say that I read it and to say I'm considering it are not the same thing, right? They are distinct concepts. So, you can read something and not consider it. I have read it. I have determined it is not good evidence. Therefore, I'm excluding it. Therefore, I'm not considering it. So I saw some people like harping on the fact that the judge, Chup, admitted to reading it. Sure. Does that mean that he did or should consider it? It does not mean either of those things. No. Reading and considering are not the same thing. Yeah. Just to say it's considered is to say it's valid evidence. So he read it, perhaps in part to determine whether or not it was valid evidence. Then presumably said it's not valid evidence. Then presumably said it's not being considered. I see no problem with any of these things. The dismissal order stated the trial court did not consider them. Yes. The trial court then ordered appellees to submit evidence of attorney's fees and costs. The court conducted an evidentiary hearing. Mignogna offered no expert testimony, did not provide alternate rate. The trial court erred in filed sanctions. The amount sought to be produced was this amount. That was a pretty large statement of facts provision. We went through 14-page review of statement of facts. That was a lot. I mean, it wasn't bad. It was just a lot. The briefs suffered from the same defects and misleading statements. An attempt to dump a series of string cites from 10 volumes of clerk record and supplements, hoping the court will do the job for him. A little bit, yeah. Although that was also a criticism of Funimation's, where they kind of did the same thing, where they're just dumping citations without actually providing the context. So, as to that aspect, I think Funimation might be equally guilty. But so far, we haven't got into citations to the court record, so we don't know whether or not Rial and Toye are guilty of this or not. But yeah, Vic was guilty of it. Funimation is guilty of it. We'll find out if they're guilty of it too. Mignogna is a public figure whose lawsuit is vengeful assault. His silence application unleashed a horde of online suppliers to publicly harass and intimidate anyone. Yeah, that is also a pretty good reason not to tell people to go forth into the night and do whatever they can to correct the record, because some people will go too far. So there is that. When that failed, he filed the underlying lawsuit filed by the War Chest. It was his money, so he has the right. Mignogna filed the underlying lawsuit for no reason other to intimidate silent speech and send a message to anyone who dared upsend them. Conclusory, but they presented a pretty reasonable argument for why that was true, going to like some of the historical stuff to show it. So, not bad. I don't know if I agree with it or not, but they presented a pretty reasonable case for why they say it's true. Mignogna's pleading together with the evidence provides a preponderance evidence. Once they met the burden, they failed to show clear and sufficient of each and every element, continue to rely on objectionable evidence, fails to meet the burden. In a brief to this Court of Appeals, Mignogna unabashedly cites the withdrawn evidence affidavits evidence without explaining that he withdrew them and trial court correctly excluded them. Well, without going back and reading Mignogna's brief, I did find it wanting in some respects, yes. Even if Mignogna had provided clear and specific, and even if court found Judge Chup abused discretion in excluding untimely prejudicial evidence, appellees can rely on several affirmative defenses to defeat the claims. Accordingly, it was properly granted in its entirety. So even if it should have been admitted, we had affirmative defenses that were valid. Fair enough. We'll get into that, I suppose. We're entitled to a full amount of reasonable fees. There was an award of fees. Mignogna's abuse of the court, along with his legion of followers, directed by Mignogna and friend and financier, internet troll Nick Rikita. Poor Nick, internet troll. That's harsh. Do we need to refer to Nick Rikita as internet troll? I know he refers to himself as a shock jock, but that seems a little harsh. Required Rial and Toye to expend more money and time to respond to the bad faith, uncontroverted evidence. We're entitled to money. Okay, fine. Anti-slap standard. Okay, we got the anti-slap standard. We vaguely know what it is. Mignogna's brief barely mentions step one, presumably because his petition shows unequivocally he sued him for engaging in two prongs of protected communication. Mignogna sues appellees for allegedly joining together, communicating with others to correctly express opinions, a public figure on the internet. Well, that's not quite what Vic was trying to argue. He's trying to argue that you're expressing facts, not opinion, but Fair enough. You want to color it that way, characterize it that way. You should. You're doing a good job for your side. The dismissal order properly granted the anti-slap motion because they showed by preponderance of evidence the claims relate to or response to free speech as defined by statute. Well, given the pleadings that seem to be operative, Isaac Wicks has a question. Yes, Isaac, I will answer your question. Please ask, and I will do my best to answer. Mignogna never actually denies he's a public figure. In fact, he admitted that he'd been to movies, been on television, and 10 conventions. I don't think that being in movies, television, and voice acting is going to do it for them. There's a lot of people who are in media who you never know, right? There are a lot of actors whose name you would never know. The conventions where thousands of people show up, and there's 30 to 40 of them, and he's been doing it for a decade, that is the one that's punching my ticket. If a judge decides to dismiss evidence due to procedural stuff, which resulted in an anti-slap, okay. Yes, that's part 2 of the question. I'm assuming you're typing. Yeah, instead of disputing it, the brief simply argues one time because the trial court failed to sustain objection. Trial court finding that Vic is a public figure and the tweets are related to public controversy is based on inadmissible evidence. However, not only does Mignogna fail to identify and articulate, he fails to obtain a ruling on objections and never sent trap letter, thus waiving any objection. He's a public figure. If a judge decides to dismiss evidence, Isaac Wicks asks, so if a judge decides to dismiss evidence due to procedural stuff, which resulted in an anti-slap, would the existence of the evidence be used to decide if the lawsuit would be considered relevant to good faith? I don't know. That's a very technical question. I don't know the answer to that question, to be quite honest. I would presume the answer is yes, but I don't know that for a fact. But good question. I presume that you could look at. I presume that you would look at anything to determine like the underlying intent, even stuff that was excluded. But I don't know that for a fact. Regardless, the evidence pointing to Mignogna's status as general purpose figure is overwhelming. I don't think he's general purpose. I don't think that's true. No. I don't think he's a general purpose public figure. I think he's limited purpose. And I think the court said limited purpose, as I recall. So I don't think he's general purpose. No, that goes too far. Mignogna's own petition states he's well known and takes photos with fans, who appears at 35 to 40 conventions and appears with fans. He has a bunch of followers. He has a fan club, blah, blah, blah. Yes, I'm sure he does, but he's not general purpose for my taste. We're not in that tier. We're not in that level. No. You'd have to show general recognition among the general public, to show general status. I don't think you can get there. I don't think you can even get close. There are 2 types of figures: general purpose, who have achieved such pervasive fame or notoriety, they're figures for all purposes, and limited purpose, for limited ranges. Yes. Even if Vic's fame and notoriety were not enough to make him general purpose, he's not. He publicly intervened and addressed controversy here on at least 5 separate occasions, making him limited purpose. Well, that and the conventions and all the rest of it, yeah, I think he's limited purpose. Aside from his general fame, he publicly inserted himself into the war. That too, that didn't help. Yes, he injected himself directly into the direct controversy. And more to the point, for my taste, directed others to do so. Even him injecting himself to defend himself wouldn't necessarily, for me, punch the ticket. Where he says, please, other people, go forth and tell other people what you think. That did it. That did it for me. On the face, Mignogna's claim implicate the appellee's right of association because they rise out of communications with serious allegations. They have the right to associate and communicate with others and communicate those common interests. To the extent they're true, sure. Even this court's decision in Dallas courts to require applying it to the claims. Blah, 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 blah. The communications between Rial, Toye, Mariachi, Denbo, and countless others were not private. Okay. Mignogna claims alleged that they communicate publicly. Mignogna himself publicly responded. Rial and Toye specifically testified the purpose behind this was to participate in the investigation, share experiences, warn the public at large, and support each other. As long as it was true, then you're fine. Yeah, I think you're fine. The most stringent reading of TCPA requires applying the statute to the lawsuit because the communications involve public participation about misconduct. I think it's a covered material for TCPA. I think the TCPA applies. So I think I think the idea that the TCPA applies is pretty solid. So I think he's a public figure, limited purpose. I think the TCPA applies, not for least reasons that the TCPA in Texas is very broad, which personally I like, but that's more a political opinion than a legal opinion, right? But it's very broad, so yeah, the TCPA applies. Yeah, it's public figure, but there's a whole bunch of other stuff, right? So as to those elements, I'm on board. Dallas Court of Appeals recently addressed similar issue and found communications that implicate free speech. Okay, we're getting into whether or not the TCPA applies. I'm just going to say yes, it applies. If a TCPA shows by preponderance of evidence legal actions based on the exercise of free speech, which I think they did in the first instance, so I think they met their step one burden. The burden shifts to show a prima facie case for each essential element by clear and specific evidence. Yes, I think they did make the step one burden, in my opinion, and then he has to come back. Mignogna failed to achieve this burden because the evidence was excluded. Okay. If a tweet is a public statement, will that establish Twitter as a public square or a soapbox? Not for the purpose of governmental action, no. Not for the purpose of, is it a public forum in the sense of First Amendment law? No. But it doesn't have to be. If you did it in a newspaper or in a magazine or anything else, then it would be apply. So no, it's not a public square or soapbox within the meaning of it being governmental action or Twitter being a governmental First Amendment applying. Not in that sense, no. You can use private communications or non First Amendment publications to do this kind of stuff. So public and protected by the First Amendment are not quite the same thing. Protected by the First Amendment, you need a governmental actor, and Twitter is not a governmental actor. Trump's Twitter is a public forum as to Trump's Twitter, yes. A decision I incidentally disagree with. But yes, apparently according to the DC Court of Appeals it is for some reason. Mignogna argues unpersuasively the trial court should have considered the petition, and understanding the case procedural history easily defeats the argument. First and foremost, this court reviews this decision to exclude evidence under abuse of discretion. A trial court's decision may only be disturbed if the decision to exclude was arbitrary, unreasonable, and without reference to any guiding rule or principle. In this case, the scheduling agreement set Mignogna's deadline to respond to August the 30th. It's undisputed Mignogna did not file until after the deadline. Okay, fair enough. How can an internal component of something be a public forum when the wider thing isn't? Because the idea is that Trump controls that aspect of it, at least according to the court's opinion, right? He controls that aspect. So the fact it's on Twitter is irrelevant. It would come out the same if it were a column, a dedicated column, or it would theoretically come out the same if it were a dedicated column in a newspaper or some other forum. But the idea is that he has control over his account. And so it's governmental action as to that particular account. So yeah, that makes sense, sort of. I think it's the wrong decision, but it makes logical sense. I think it's the wrong decision, but I understand the logic of it. Thank you, Radically Moderator, for saying you enjoy my content. I appreciate it. I do my best. Although the trial court would have been fully within its discretion to exclude it, Graham Mignogna request to leave the file late. Even with extra time, though, it's still fatally deficient. Yeah, again, in the abstract, in the absence of any specific rules to the contrary, trial courts have wide discretion in terms of trial management and when things have to be submitted, and can put binding rules on you, and as long as they're vaguely reasonable, they're going to be upheld. Trial courts have, in the absence of any specific rule to the contrary, the trial court has massive discretion to say what has to be done when and how and all kinds of crap. They have wide latitude to manage their courtroom. They are they say tell it to the judge, right? Well, there you go, man. Massive latitude. Which is incidentally why rule number 1 of trial practice is don't piss off the judge. Don't piss off the judge. Yeah. Even with the extra time, it was fatally deficient. It was rife with missing citation, blah, blah, blah. No evidence. He tried to bolster it by filing a Second Amendment petition, correcting those errors and filing dozens of citations that were previously omitted. Unfair notice, unfair surprise. In particular, a Second Amendment petition also sought to add unsworn declarations that were nearly identified to withdrawal affidavits. Well, I have no objection to that, right? That would be the reasonable alternative. An unsworn declaration instead of an affidavit, right? Okay, fine. I mean, I don't know to the degree to which that they can be done, but, I have no particular objection to that. Including the declaration of Chris Slosh that Mignogna relies on 3 days before. The 3 days before part, I object to. And so do they. And I think justly so. They failed to comply with it by not including a date or birth address. It's a minor informality. That part's not going to squeeze them, right? Appellants objected to the admission and pleading with the trial court ostensibly sustained. Ostensibly? You're not sure? Ostensibly sustained? So you're not even sure if they sustained it. Okay. Wow. That's surprising. That's like almost an admission. We're not even sure if they sustained it. That's ostensibly sustained. Okay. Mignogna argues it was neither surprising nor prejudicial. I don't know, man. It feels a little surprising and prejudicial. However, the extent to which the Second Amendment drastically alters previous pleadings and sought to bolster it contradicts that argument. I have to concede that point, man. It was pretty materially different. It went from like 20 pages to like lots more. I forget what the number was. It was like 250 or 400 is a big number. So it's a pretty big difference, yeah. I have to concede the point. I would be irritated too. In addition to being filed just 3 days before, the Second Amendment included over 34 new paragraphs, amended signed declarations, attempted to shoehorn inadmissible exhibits not previously included. It sure did. In addition, the Second Amendment included a new 7-page argument, conspicuously titled Prima Facie Evidence, that was blatantly an attempt to augment the untimely response. Yeah, it was, well, I don't know that it was an attempt to augment the untimely response. The way that's being phrased is like they were doing it to I don't like the way the sentence is phrased. I don't think that was what was behind it. He was trying to show why he had prima facie evidence, which is what he should be doing. When he was doing it, though, is a problem. These substantive and significant additions were wholly improper, and trial court properly excluded them. The trial court was clear it did not consider them because of withdrawal. Again, to all my Vic fans out there, that the trial court read them has nothing to do with whether or not the trial court considered them. These are different concepts. So yes, I'm sure the trial court read them. Does that mean they considered them? Nope, it does not. The trial court also did not consider additional evidence submitted within the Second Amended petition because it was filed late, in violation of the agreement. I really hope at some point someone is going to go to the exact language of the agreement to show me why it does or does not apply. Please, someone cite to me the exact text of the agreement and why it does or does not apply to this situation. Because if it's that solid, we can just end the discussion. If it's that clear that it's within the agreement, then I can just shut down the stream and be like, Vic is going to lose. He has no hope whatsoever. So just give up all hope, abandon all hope, all ye who enter here. Okay? At some point, it would be nice if someone was going to cite the exact agreement and show me why it does or does not apply, so I can say we're just done here. Is anyone going to do that at any point? That'd be great. There's been no showing of trial court abused its discretion with that regard, and exclusion withdrawal in the affidavit should be upheld. To the contrary, the trial court was grounded by sound principles. No, we're not going to discuss the Rule 11 agreement. No, we're not going to discuss the Rule 11 agreement. We're not going to bother to actually discuss the agreement and what it says and why it does or does not apply to the situation. We're not going to actually discuss it in any detail. Which makes me conclude that the Rule 11 agreement isn't as good for you as you are fronting. If the agreement was as good for you as you were fronting, you would just say, here's exactly what the agreement says, and here's why it applies, and end of analysis. But you're not doing that, which leads me to believe the Rule 11 agreement isn't as good for you as you're fronting. It would be wonderful if this was guided by the Rule 11 agreement. We could just be done, but we're not done because you're not telling me why it applies, which makes me think it doesn't apply, which makes me think that Beard has the better end of that argument. You know, it's like saying I have such great evidence. I have such wonderful evidence. I have the best evidence. You know, just wait till you see my evidence. You're going to be so surprised and wonder how great this evidence is. It's like at some point, can you stop selling me and show me the product? That would be super. No, you're not going to do that? Okay, that's great. Nah, that's great. To avoid dismissal, he must show prima facie evidence, must show more than simple notice. He must provide. Yes, he has to do all those things. That's true. To be defamatory, they must be materially false. A statement is not objectionable unless it asserts objectively verifiable fact rather than opinion. That's true. You can only get two facts, not opinion. Fair enough. Mignogna defamatory claim fails because he failed to provide full context for the defamatory statements, relying instead on baseless speculation. Defamation does have to be understood in full context. That's fair. Defamatory claims are based on libel, which requires the court to examine the entire publication. Fair enough. That's fair. While Toye is alleged to have posted hundreds of negative tweets about Mignogna in the context of a Twitter war, context is critical. It's particularly true because the nature of discussion gives context to debate and meaning of the hyperbolic tweets. Fair enough. That the context may reveal them to be hyperbolic rather than literal, right? So whether or not you're using them literally or hyperbolically may be brought on by the context, right? Yeah. Some guy whose name I will not attempt to pronounce in chat says, there's no evidence on record to show that Beard violated the agreement, so there's no evidence of the agreement itself. Well, that's what I'm saying, man. That's exactly what I'm saying. That's frustrating for me. That's frustrating for me because I agree with you. I'm agreeing with you. I'm not disagreeing with you in any way. It's just very frustrating to me because both Funimation and now Rial and Toye have said, man, this Rule 11 agreement, man, this is the best agreement. It totally governs our situation. It's just the best agreement. And neither of them are mentioning it, which leads me to conclude it doesn't govern. It's just very frustrating because it's like, oh, I have such a great product. Just wait till you see my product. What is the product? Just wait till you see it. Any day now. It's a little frustrating, yeah. But yeah, I'm not disagreeing with you, which name I'm not going to attempt to pronounce because it is many letters and figures. So yes, I agree with you. One example of the petition proves the point. He included a screenshot of one tweet to allege Rial defamed him by saying he is legal definition of harassment. Okay, this tweet without context fails to say who he's referring to, what she's responding to, or who he is. Fair enough. I mean, you need enough context to say who we're talking about. So that's fair. I can't disagree with that, you know? Mignogna further fails to identify whether his tweet is defamation per se or per quad. A common failure. I'm not sure you're necessarily obligated to say which it is. You know, I'm not sure you're necessarily obligated to say which it is, but okay. Mignogna employs the same strategy with Toye's tweets. He's down because he took advantage of girls' buddy. How about get a grip on reality and stop harassing? Over 100 accounts, still more to come, and you defend this person. Get a life. You know, without more, it doesn't tell you who we're talking about. That's true. Yep. This tweet in the petition without context fails to establish who's referring to. Yes, it does. Absent appropriate context, you cannot determine they're defamatory, much less what they mean. I can't disagree. You know, we need enough context to know who we're talking about. That's true. Yeah. Vincent says, thank you for having an unbiased view that our commentators. I'm in law school. I pretty much agree with you on Ty Beard. Well, thank you. I try to be fair. And I try to call it like I see it, right? Just call it like I see it. Like, here's what's good. Here's what's bad. Here's what's strong. Here's what's weak. And like lest you're not paying attention, like I am being both supportive and critical of this as I'm reading it. Like, here's some strong points. Here's some weak points. You know, like, so I'm just trying to be fair, like, as to what I agree with and what I don't. Even accepting as true they refer to Mignogna, the tweets came during a heated internet debate. Rather than include the context, Mignogna routinely serves excerpts out of context and merely concludes they're defamatory. That's a reasonable argument. It's a little conclusory, you know, because ideally you'd want to show full context, but like, you know, they're basically like just saying like, it's kind of like showing that they didn't make their burden, right? They didn't make their burden rather than me show you why they're like explicitly wrong. So I don't really object to this. This is fine. They didn't make their burn. I'm not going to explain it to you because they had to explain it to you. It's not my burn to explain it to you. And it's not. It's not their burn to explain it to you. Fair enough. Is it a comparison or a conclusory? Why not both, man? Why not both? All his tweets occur after the conventions terminate Mignogna. No causation. If that's true, that would be fatal as to the tweets. But maybe not fatal as to the direct calls they purportedly made. So if the tweets came after the convention, after they terminated, then it can't be the tweets, which would be a dispositive argument as to the tweets. Can't possibly be that, right? Viva starting a stream? Hold on. I have to go yell at Viva. Hold on. I have to tweet. I have to message Viva. Hold on. I have a cell phone. I'm going to write Viva. Be like, okay, starting a stream? Question mark. Covering the Vic Mignogna case that will not die. Smiley face. Some friendly competition for views. For views, I guess. Lol. Smiley face. Unless you want to get wasted on stream, I am always down for that. Down for that. Smiley face. I would like to be noted for the record that I am not mad at Viva in any way for him hosting a stream. I'd like to be noted for the record. I'm trying to be teasing. So hopefully he will read in the fact that I'm teasing. I'm not actually mad at him. He can, of course, stream anytime he likes. So I'm just trying to be teasing and like a little bit of friendly banter. So hopefully the smiley faces will alert him to the fact that I'm not trying to be mad or call him out. I'm just trying to be friendly. A little friendly, little tease. So I just like to be noted for the record. I'm not mad. I'm just trying to be teasing about it. So very good. All right. Let's carry on and see if Viva tweets me back or messages me back. The recreational McNewts are on their way to Viva Studio. This is playful. I'm not directing you guys to do anything. Unlike Vic, I am not telling you to do anything. And it's just a little bit of friendly jabbing. It's just a little bit of friendly jabbing. Like, I try to do this and try to just be a little friendly. He can have a tweet. He can have anything he wants anytime. It's perfectly fine. Please be nice to Viva. He's my friend. Please do not be mean to Viva. I like Viva. Thank you very much. I'm going to get in trouble. Oh, it's a delayed email? Oh. Okay, so it's not actually happening right now. So now you made me look like an ass. Well, that's just great. Thanks, guys. My friendly banter is now making me look bad. That's great. Thanks, guys. That's fun. All right, so now I have to tweet him again because now he won't understand what the hell I'm talking about. No. Oh man. Yeah. Well, he's going to notice when I send him a text message to his cell phone because I have a cell phone number. Oh man. All right. Larry, we're away. Toye also testified context of tweets were missing. Okay. But telling someone bye, have fun with the predator. Can't wait for you. I assume your apology. It seems to be your, it looks like. And who are you talking about? Look, it's not this one. I'm not sure on this. I'm not sure. I don't know who or what the previous conversation showed. Could have been anyway. If you're a betting man, who you say you're talking about, I don't know. Yeah. The untimely response was so poorly briefed it lacked proper citation, including an exhibit that contained 341 pages out of context. Mignogna does the same thing with the court's record. In addition to being out of context, a state cannot be defamatory until it tends to injure a living person's reputation and expose a person's public hatred. To be clear, Mignogna concedes the negative press independently damaged his reputation and makes no effort to show what the effort was caused by Rial. Okay. Texas courts are clear Mignogna is liable proof. I don't think so, but please tell me why. Although the statements Schwartz complains about may be false, the early newspaper articles that disappointed or described the conduct would have ruined the reputation. We need not indulge in all the negative details. Let's suffice to say he's been targeted with extensive negative media attention, so much as possible to believe his reputation could be further damaged. Yeah, Vic is not in this category. Vic is not in this category. He is not liable proof. Yeah, who do I need to time out and ban for saying that Vic started a stream? Isaac Wicks. And we're not going to do that right now, but yeah. Yeah. Standard defamation requires some degree of fault, which in the case is actual malice. He's a public figure. He limited purpose, yes. Mignogna must not only show their faults, but also show mate with actual malice. To show reckless disregard, Mignogna must show more than make conclusory assertions. Mignogna's brief completely ignores high and pleading. Show actual malice, it certainly does on the other ones. Mignogna attempts to show actual malice by pointing out Raul Laird claim, I know without question you hurt people very close to me. There's nothing defamatory about the statement because it's true or opinion. That's not opinion. That's a statement of fact. That's not opinion. That's fact. Concerning Toye's tweets about Mignogna assaulted women, Mignogna argues only that Raul could not know that Vic assaulted them. As is the case with all, he fails to show and entertains serious doubts as to the truth, or even that they're false. You know, we won't be that precise about it, but it is a statement of fact. Mignogna disposed Toye and Rial, and yet conspicuously does not point to any testimony which shown either of them known their statements were false when made or reckless disregard for truth. He simply concludes with no basis he believes statements are untrue. In fact, all evidence in the record points that reveals that Pellies did not act with actual malice and sincerely believed every word they wrote. Rial truthfully testified against assaults against her, engaged truthfully in the investigation, and released statements online because she felt it was important to corroborate. Likewise, Toye testified about his belief of truth of statements. The appellate record overly shows did not make any defamatory statements with actual malice. On the record that we have, probably true. The stated cause of action, Mignogna must prove each element of his with clear and specific evidence. There must be reasonable probability, the defendant's conduct, blah, blah, blah. Did not prove actual interference. Okay, let's go with actual interference for the contracts. Do we have tortious interference? Because I think that their argument on the defamation is pretty good. I don't think it's rock solid, but I think it's pretty good. And I think also, like, on balance, Mignogna failed to show enough to show it. And also, like, the idea that some of it's hyperbolic and shouldn't be understood literally because of Twitter war and so forth and so on. It's like, yeah, it's not horrible. You know, I don't think it's like a slam out of the park, but I think on balance they probably are winning on that argument. But the tortious interference is the more interesting case for me. The tortious interference is the more interesting case. So let's see. As an initial matter, Mignogna failed to introduce a single contract or anticipated contract to support the claims. Counsel for Mignogna outright recognized that Mignogna did not present any written agreements. It was not a very good hearing, that's true. Which suggests to Kamahikan he relies on the withdrawal and defective affidavit and admits he was ultimately allowed to attend, which doesn't really go to the issue ultimately of tortious interference, although it might go to the issue of damages. Like, I don't think that, you know, it would show that you tried to tortiously interfere, and it may be evidence of pattern. So I think it's relevant as to that. Like the fact in Vanderlyn, not a single contracting party, actual perspective, testified they had terminated contracts based on something Appelli said or did. Yeah, did you have anyone say that they did it because of those tweets? or because they called them directly. Did you get anything from anyone that said, I did it because Vic called me? That was when I decided. Do you have anything like that? Because I don't remember reading anything like that. And maybe it's buried in one of the attachments to the second amended, but it wasn't in the original pleading. I don't remember any of that where it's like, yeah, this guy said it was because of this. You're not showing the causality. It's hard to disagree with that. Compounding this deficiency is that Mignogna refers to two conventions that Mignogna did not even include in his petition or argue below. Compare the brief with first amended. Oh, he's trying to supplement the record in his brief? Mignogna refers to two conditions in his brief they did not even include. No. Nope. That is a no. You can't do that. Nope. No, you definitely cannot do that. You cannot bring things into your brief that are not in the record below. No, absolutely not. Not allowed. Mignogna's brief suffers from the age-old fallacy post hoc ergo propter hoc. Yeah, which assumes simply because something occurred, it was caused by it. I could not agree with this more. Like that is a very good summary of the problem with Vic's brief. It is very post hoc. They did this. It was because of this. No, you have to show something. Show something, anything. A statement from somebody would be helpful, yes. Temporal proximity is not enough. It's true. Conjure, guess, or speculation cannot survive clear and specific scrutiny. The timing of alleged terminated contract standing alone is insufficient and too speculative. Proximity requires both proof of causal facts and foreseeability. The test for causal fact is where tortious misconduct was a substantial factor in bringing about the injury. That is a factor without injury would not have occurred. Mignogna's evidence does not meet the standard. Based on what we've seen so far, I cannot disagree with that. Yeah, I cannot disagree. It certainly was not the case in the hearing, on the TCPA hearing, where the judge said what contracts basically, and he and Ty was like, I don't know what you're talking about, like repeatedly. It's like, yeah, you're not showing the stuff you need to show. It wasn't in the original petition. It wasn't in the first amendment. If it was in the second amendment, I don't know. And the trial court properly excluded it. So it's like, yeah. Mignogna unpersuasively suggests he lost his scheduled invitations to appear because of the communications. At least one of the communications occurred before the tweet. With regard to Funimation's termination, Mignogna never showed Funimation terminate him because of what Rial is alleged to have communicated. To the contrary, Denbo submitted an affidavit stating the decision was based on several factors, including an interview. As to 6 conventions, canceled the appearance after publication of negative press. Why are they referring to negative press in capitals? It's proper noun now? Mignogna's evidence is non-existent with respect to the specific appellee's alleged actions. In other words, Mignogna offers no evidence that Rial, Toye, or Marchi were specific reasons they canceled the appearance. That is, as I understand it, factually correct on the record as we have it. Mignogna concedes the negative press irreparably damaged his reputation. The articles published from at least January 2019 and themselves a reaction to public outcry. Importantly, sources for the articles were not appellees, but rather voice actors, cosplayers, industry professionals, convention employees, and former fans who identify and described in independent allegations. Mignogna simply cannot, in fact does not even try, to separate the influence that negative press and other statements cause from the conventions. Yeah. Maybe there's a publisher called Negative Press. Well, that would explain a lot, yes. As with his defamation claims, Mignogna fails to offer any evidence between the nexus of the conduct. The Houston Court of Appeals held that business showing of declining general revenue is not sufficient damages. Mignogna did not attempt to explain how damage might have been natural, probable, and foreseeable result. Trial court failed to establish a claim for conspiracy. Civil conspiracy is a vicarious liability, not independent. It fails because the underlying fails. Sure does, my friends. It sure does. It fails because the underlying fails. Would have been real nice to have some of that evidence of that discord somewhere in the record. Someone even saying it exists, and here's what I saw in it. Would have been nice. Would have been nice to have. I feel like Ty may have made some mistakes along the way. I feel like Ty might have made some mistakes. Yeah. The evidence as a role undermines Mignogna's claims for defamation. Consequently, there's no basis. Yep, yep. Okay, you're going to talk about conspiracy law. I'm already there. Even the non-movement can make showing of each itself. They still must dismiss if the moving party establishes by preponderance each essential element as to a valid defense. If you can show the valid defense, sure. Mignogna's brief adds to attempt to add entirely new defamatory statements and never subject to petition filed. You can't do that. You can't add any things in the brief. The only alleged defamatory statements that were subject to litigation are alleged defamatory states, not as Mignogna now would have statements made. The court need look only to the amended petition to see the entire lawsuit was based on these tweets. Defendants have tweeted false defamatory statements. DMA tweets were defamatory. Statements knew they're reckless. Mignogna's claims is actually pled alleged following instances. Mignogna fails to establish statements 1 through 3 are defamatory. Mignogna fails to establish his defamatory because it didn't have any negative aspect. Well, let me just say, in my humble opinion, it is my humble opinion that Funimation and Rial and Toye's lawyers are doing a better job than Vic's lawyers. Yeah. Yeah, the original Toye that created all the pus was a person who mistook Vic. Well, be that as it may, if we want to sue the original person who created the tweet for their defamation, then let's go nuts. But we're not suing that person, are we? No. So, like, did that person create defamation? Maybe, but is that the issue? Not really, not the moment. You know? Doesn't matter. There's a bunch of alleged statements. We're going to go through them one by one. The statements are protected by qualified privilege. Qualified statements are made in good faith. Rial unquestionably made them in good faith. She shared her experience because of cooperating with the investigation. Toye, as a fiancé, was aware of multiple things. Contemporaries articles where Predator shows a matter of public concern. To the extent you're talking about the communications with Funimation, I think you're there. Yeah. It wouldn't be malice if you mistook them. Yeah, that's probably true too. Yeah, I wasn't saying you could win for defamation. I was just simply saying it was irrelevant. But yes, you're right, Isaac. If you just made a mistake, then it's not actual malice. I can't disagree with you, Isaac. You're right. Mignogna's liable proof. No, he's not. Not that it matters at this point. And so we got a cross appeal for damages, which I don't really care about that much, to be quite honest. Maybe they'll get some more money, maybe they won't, and that's the end of that thing. And we got an appendix with the final judgment. That's fine. We got an appendix with granting leave to file an amended response, and some blah stuff, and some vicarious liability, and some remedies code for trial matters. Sure, why not? Okay, great. That was fun. So yeah, I think the thing that's really killing Vic here is that he doesn't have, as far as I know, any statement other than Slotich or whatever his name is. He doesn't have anything from anyone other than him that shows that that Rial or Toye contacted a convention directly to say don't do this, don't hire them. They don't have any evidence of any direct outreach, or even that the people directly relied on the tweets from these people in order to do it. You don't have any statements like that on the record, right? And even as to the one from Slotich, which person's name I can never pronounce, as they point out, he ultimately got there. So his damages are relatively reduced as a result. So there's arguably no damage. Right? So as to defamation, he didn't argue the right context. He didn't show what it was, and it was hyperbolic. Okay. As to directly communicating with the conventions, you didn't show we did that. You only showed the one instance. It didn't harm you that much anyway, and it's not part of the record, and you didn't show anything as to other conventions. And also, incidentally, you're trying to amend your brief to bring in other stuff, and you can't do that. Okay. As to conspiracy, you don't have evidence of that because you don't have the Discord. Okay. You're a public figure. So you can't prove malice. Okay. So I think on balance, again, I have to agree with Rial and Toye. I think they're illegal. I think their argument is better. I don't think it's quite as solid as Funimation's. We gave Funimation an 85% chance to win. For them, we will give Rial and Toye a 75% chance to win. But I think that their argument's pretty solid. There's some defects, and I pointed it out along the way. There's definitely some problems. I definitely don't think he's libel proof. I don't agree with that. There's a couple of other things where I thought there were minor points where I like, yeah, there's some points here. But on balance, I think that they have the right argument. You didn't really show the defamation from the tweets because you didn't show enough. You didn't argue the right context. They're hyperbolic anyway. They're part of protected speech. You didn't show our direct interference. You only have this one example. It didn't harm you anyway. You don't have these communications were protected because they're part of public interest. They're part of our investigation. You can't show evidence of conspiracy. You don't have that. You can't show our direct interference with any of the other conventions. So it's like, okay, well, on the law, I think Rial and Toye have a pretty solid argument. Now, of course, there is this issue as to the word count or not, as to whether or not it's in excess of the word count of the rules. I don't know at this point. At this point, I don't really care that much. I don't care. I just don't care because the strongest remedy that that a Beard is going to be able to get is to make them file one that's shorter. Ooh, yes, hypothetically, the appeal court could strike the brief completely and sanction them by not allowing them to amend. So yes, hypothetically, in some hypothetical universe, that is possible. However, that's not going to happen here, guys. It's just not happening as wishing to think it is. All right. So the Vic people are like, it's an excess. They're going to strike it and forbid it from being entered, and then Beard is going to win because it's the only brief on record. Is that hypothetically possible? Yes. Is that going to happen? Absolutely not. Not a chance. No, absolutely not. The strongest remedy that the court is going to do is make them file a different brief that's shorter. So, do I care that much? Not really. Not really. So, it's, whatever, it's fine. And that assumes, of course, that it's in excess of the word count rule, which I don't know that it is. All right, I know that Nick Rikita did some analysis of why it is or is not in excess of the word count rule. I'm not going to get into it. Whatever. I just don't care that much. Can't they strike the parts instead of the whole thing? No, presumably they may. What parts? Right? It's because it's not like that easy to say that you make them file a different brief is what you do. The appeal court would make them file a different brief, and so they filed a different brief. They filed an amended brief. The appeal court, or they would have to like retroactively ask for permission and get permission, which is another things they could do. So the court could say like, please file a different brief and say, can we just have this admitted? And the court could say, oh, okay. So they could ask for permission after the fact too, which again might happen. So there's no ruling from the appeal court yet. This was just filed on the 31st. There's no ruling yet. The ruling right now is that Vic is liable and he has to pay them like $250,000 or $500,000 or whatever it is in damages. Yeah, retroactively ask for permission, ask for forgiveness, yeah. Which assumes it's in excess, which I don't know that it is. Because I'm not that familiar with the rules, so, Could be, might not be, I don't know. But, that's the only real, like, if there's a minor defect, I would consider that to be a minor defect, to be quite honest. Right? I consider it to be a minor defect. They want to issue an order to file a corrected one. Sure. I think that's about the most severe sanction you're likely to get. And of course, we don't know when the appeal court will hear this because, in case we forgot, like the entire world is shut down right now. So there's no immediate scheduling. But whenever they have this, I think I'm going to show up in person and go to the oral argument. I think it'll be fun. You're welcome, Vincent. I'm glad that I'm igniting passion in these legal topics. I'm very happy. So thank you for the people who were here. I got no chat revenue today. Very, very sad. No super chat revenue for Blackleaf. Very disappointing. But if you like this chat, if you like this stream, please give it a like. We will be back we still have Monica's brief to do. So we'll do that at some point and we'll see where we are. And I might be back on later today with a Factorio stream. I I don't own Factorio, but it looks like fun, and I might download it and try it. So we'll see what happens. But until later, my friends, hope you're well. Bye.